Well, good morning, everybody. And for anybody who doesn't know me, I'm David Roberts, and I'm going to be moderating this first session, as Julia mentioned. I'm delighted to be able to introduce this morning's keynote speaker, Justice Jennifer Coate. Justice Coate is a judge of the Family Court of Australia. Prior to this, she held a number of appointments, including as Judge of the County Court of Victoria, State Coroner of Victoria, the inaugural President of the Children's Court of Victoria, and Senior Magistrate and Magistrate of the Magistrates Court of Victoria. During her time as President of the Children's Court of Victoria, Commissioner Coate oversaw the establishment of the Children's Koori Court, so connections with a lot of our discussion yesterday. Justice Coate has also worked as a part-time Law Reform Commissioner, a solicitor in private practice, a solicitor for the Legal Aid Commission of Victoria, and in policy and research for the Victorian Government. Now, of course, it's in her role as one of the 6 commissioners of the Royal Commission into Institutional Responses to Child Sexual Abuse that Justice Coate is speaking to us today. And anybody who's been following the work of the Commission will understand the significance of records and record keeping and the issues associated with records and record keeping in its work and in its impact on victims and survivors. And many of us will have read the Royal Commission's recent consultation paper on records and record keeping practices, and some of you will have made submissions in response to that paper. So we're delighted that Justice Coate has agreed to give us her perspective on records and record keeping as an update from the Royal Commission. So please, Justice Coate.
Thank you, David. I too wish to acknowledge the traditional owners of the lands upon which we meet, and I pay my respects to the Darug people, and I also pay my respects to all Aboriginal people and Torres Strait Islanders present here today. I was indicating to David that someone at the office overheard me yesterday saying that I was coming to do this presentation. And I said, I'm going to the Australian Society of Archivists. And he popped out of the office and said, Judge, I think you'll find that they refer to themselves as archivists. To which I said, thank you for telling me that, and almost immediately someone else popped out and said, I'm not so sure about that. I've heard them referring to themselves as archivists. So I can assure you, I checked with David this morning, and you will forever in my mind be archivists. Look, I would, on behalf of the Royal Commission, very much thank you for giving us the opportunity to present to you today. In particular, I do want to acknowledge, I think, the presence already of Professor Sue McKemishin and Barbara Reid, who are going to be on the panel after this presentation, and also 2 very distinguished members of the non-archival community, Bonnie Jurek and Frank Golding, both known to me and both doing, from our point of view, extremely important work in this area. As David indicated to you, I am one of 6 commissioners, the 6 commissioners appointed to Australia's Royal Commission into institutional responses to child sexual abuse. Now, today, obviously, I want to get to come to some of the issues of mutual interest to you and to the Royal Commission. But I thought before I did that I would take the opportunity to give a brief overview to you of some of the work of the Commission and the way in which we are working. Many of you would know that this Royal Commission commenced in January of 2013, and it was established, as Royal Commissions always are, under what are called letters patent. And the basis of our inquiry was to, as you would understand from the title, to inquire into institutional responses to child sexual abuse. In particular, and in summary, we have been directed to inquire into what's generically referred to as the prevention area. In other words, what governments and institutions should do to better protect children against sexual abuse in an institutional context. What is best practice, to inquire into what is best practice in the encouraging and reporting of allegations and responses to those allegations of the sexual abuse of children in an institutional context. What can be done and should be done with respect to reducing or eliminating impediments to those appropriate responses. And finally, but certainly not the least of our areas of inquiry and work, are about alleviating and addressing the impact, well, understanding first and alleviating and addressing the impact of institutional child sexual abuse, including ensuring for victims through redress, criminal justice processes and support services that these issues are properly addressed. So it doesn't take very long to understand the huge breadth of the work that we're engaged in when you just look in brief summary at what's contained in those terms of reference in our letters patent. The number of allegations of sexual abuse of children that have come forward to the Commission since, or indeed before our official work commenced, but since our work has commenced, has been for us and probably for the community in general, the numbers have been both substantial and indeed profound in their shocking proportions. We have found that child sexual abuse has occurred across a range of institutions, across states and territories, indeed in all states and territories. And we have also found that child sexual abuse is not confined to one type of institution, indeed, or any particular time in our history, although I'll say something in a moment about the delay in reporting. And as you can imagine, we have heard an enormous amount about the suffering and the trauma endured by victims and survivors as a result of these abuses. What started out for us as originally we all got appointed to the Commission for a period of 3 years with an understanding that we would report at the end of 18 months to the government about what could be achieved in those 3 years. As a result of that report, our commission was extended now to December of 2017, so that will be a total period of 5 years. And between now and then, of course, there's a lot to be done to make our best endeavours to ensure that we create a continuing legacy in which the communities and the community in general can feel safe in placing children in the care of institutions. And of course, part of that legacy will be indeed in our own records, and I'll return to this. The Royal Commission has heard from victims and survivors of child sexual abuse, and we've heard from them in a variety of ways. So we have received hundreds of written accounts from people, that they have sent into us as one of the ways in which to communicate with us and carry their stories to us. We have had people speak with us in what we've called private sessions. And of course, we've had people giving evidence in the more formal setting of a public hearing. And it's the combination of all of that material together with our research and policy program, including a number of community and public forums as well as some private roundtables and forums, that we have endeavoured to inform ourselves and continue to inform ourselves as thoroughly as possible. Now, the private sessions, let me just go and give you a little bit of an understanding of that work, because they are a very unique process for this Royal Commission and have not been engaged in before in any other Royal Commission. Indeed, we sought an amendment to the Royal Commissions Act to engage in those private sessions and to ensure the confidentiality, the complete confidentiality of the information that people bring to us in those sessions, and indeed sometimes the written material and photographs and other objects that people bring to us in those private sessions. It is our primary way of fulfilling one of our terms of reference, which is to bear witness to the abuse and the trauma that has been inflicted on those people who as children suffered sexual abuse in an institutional context. The number of private session requests that we've received to date is a clear indication of the need for an avenue where victims and survivors of abuse can confidentially talk to someone in authority about their experience. I checked our figures for the purposes of today's presentation, and between the 6 of us to date, as at the 5th of October, we have now completed over 6,000 private sessions where we've heard personal accounts of survivors and, on some occasions, family members in those private sessions. I can tell you that we also, as at this week, anticipate that as at the end of this year, we will have still around 2,300 people waiting for a private session. For this reason, because we must finish in December of next year, sadly we've had to close our private session registrations to allow sufficient time for us as the Commission to ensure that we, for every person that we've engaged with and promised a private session to, that we can actually complete those by December of next year. So we closed our registrations, and so that list that I've said of the around about 2,300 people will mean that we can, working very, very solidly through to next December, as well as completing all of our reports, complete those private sessions. All of our private sessions are audio recorded. On a number of occasions, as I've said to you, attendees will bring documents into those sessions, some of which we take copies of, some are considerable volumes of documents, and we'll sometimes take copies of things that we think may be of relevance to an area of work that we're engaged in, obviously with the consent of those who bring the documents into the room. And a range of other objects, sometimes photographs, articles out of old school magazines, or sometimes photographs of the institutions where those people were placed as children. We have, in the course of that amendment to the Royal Commissions Act that I indicated to you, was obtained for the purpose of setting up private sessions, we have a specification that for the purposes of the Commonwealth Archives Act, the 1983 Act, any records that relate to private sessions or contain information obtained at a private session will not be publicly accessible for 99 years after they've been created. That, of course, reflects a number of things, not only the historical importance of the records, but and ensuring that the stories themselves are of that trauma and suffering in our history are recorded for all time. But it also ensures that the sensitive nature of those documents are protected. And that is, I'm sure you won't be surprised to learn that for a number of attendees at private sessions, they seek to understand and be reassured about the confidentiality both of what they tell us and what they bring to those private sessions. And a number, indeed, have expressed concern even about the possibility of the next generation of their family being able to access the information that they've given us. As I have indicated, that in a number of those sessions we will get material other than the traditional understanding of documents, and as a result of that, some of our staff have made contact with both the National Library and the National Archives, and as I understand it, as at this week, the Library have indicated that they would be pleased to take some of that material into their collection, as they've specified, as long as the material is not required by the National Archives. So I'm told that that's still under discussion exactly how that's going to work. And we, of course, will discuss that with the attendees who've brought that material into private sessions. We are very much aware that some of the material, I should say, we've even had some quite large pieces given to us, which include paintings and I think perhaps even a sculpture. So we're very aware that the material may be of some national significance, certainly in its documents in their original, traditional form of documents in their original hard copy form. And as I've said, this is still a work in progress. We have a specific working group inside the Royal Commission, as I'm advised this week, working with National Archives to formalise both the requisite legislative arrangements as well as indeed our final arrangements for our own records, which will be very substantial. So let me just come back now to public hearings. So private sessions are obviously a very significant part of our work. Our public hearings are one of the most visible parts of the work of the Royal Commission. And indeed, today, as we speak, in about 35 minutes, our case study number, I think 45, we're up to, will start in our hearing rooms in the city. This particular case study will be examining, in particular, so it's a schools-based case study. It'll be examining, in particular, the treatment of problematic or harmful sexual behaviours of children and young people towards other children and young people in institutional settings, and as I said, with a particular emphasis on schools. Many of you would know that our previous public hearings have covered a wide range of institutions across a wide spread of geographical locations. People have often asked how we make decisions about which matters go to public hearing, and it's a good question because, again, for those of you interested in volume, we were advised this week, as at this week, that we have had over 3,000 institutions reported to us. So we obviously, and that figure's going up, we obviously have to make very careful decisions about which matters we pick out for public hearing, and we endeavour to do that by looking at the range of systemic issues that are being identified, in particular through private sessions and written accounts, and then endeavouring to make a spread across the states and territories and geographic locations, and highlighting those and examining those systemic issues in that way. Those public hearings, of course, we well understand are very much also a way of enhancing the community's awareness of and understanding of the nature and the circumstances, and of course the devastating impact of upon a child of sexual abuse. We, as you heard me indicate, we have engaged in 44, I think we're up to case study 45, public hearings prior to this, and we will then, before we complete our public hearings regime, we will do some full sittings that will require us to have a look right across the systems that we've been engaging in. We also have a considerable range of pieces of work underway in our policy and research areas. At the last count, I think we had we had over 100 pieces of research that we had undertaken as the Commission, and that work continues and very much informs how we're shaping our thinking on a range of topics. In our research and policy areas, as I've indicated, we have a range of topics that stem from trying to understand causation all the way through to best models in terms of prevention, school-based programs, and so on. Many of those research papers are already published on our website, and I invite anyone who's interested in looking more closely at a particular topic to go there. Each of our public hearings, of course, is preceded by a period of intensive investigation and research, and in terms of our own records, as I indicated before, you can imagine the breadth of that traditional form of documents that we have acquired. Again, the advice that I have is, since our inception in 2013, we have issued 3,022 notices for the production of documents, so they're compulsory notices, including from governments all the way through to a variety of private institutions. And again, the information that I have is that these documents alone that we've acquired by way of compulsory notices equates to around 586,250 documents, all of which have been reviewed and analysed by our Commission officers for the purposes of giving direction to our work. That power to compel documents from relevant institutions, of course, is one of the important powers of any Royal Commission, but a particularly important power for this Royal Commission. So the range of documents, just to give you a sense of them, that the powers have been used to compel, range from notes of incidents, in other words, back at inside, for example, a school where a note of a complaint may have been made, with the emphasis on may. Allegations, just more general allegations of concerning behaviours inside institutions. We've compelled insurance claim documents, which of course have been a very important source of information. We have been able to compel that otherwise sacrosanct area of communications between lawyers, which has also been a very important a body of information that we've been able to obtain. Personnel files, complaints registers, training manuals, internal policy documents. And so you can readily see, just on a quick flick through some of those types of documents, that our records are a crucial aspect of our own ability to investigate and understand what an institution knew about incidents of abuse and how they responded, and of course implicit in that what records they kept, in what form, who had access to them, whether or not they were passed on to the next regimes of management, and so on. So as I've mentioned, the archiving of our own records is a considerable task, and it is being undertaken with the assistance of the National Archives, and I'm also advised, as well as the Council of Australasian Archives and Records Authorities. We have, as David mentioned, in amongst our policy and research work, produced a consultation paper. In fact, it's our most recent consultation paper on records and record-keeping practices in institutions that care for and provide services to children. The submissions process for that paper has closed now, and I'm sure that some of you in this room have made a contribution in some way to that consultation paper, and thank you for that. We're currently now, our team working behind the scenes are currently considering all of that material, and it will very much help us shape our final recommendations, which will be published in December of next year. I should just pause for a moment to say that, to make clear to you that in this context, when we are talking about records and record keeping, we have adopted the definition of records set out, I'm sure, in a document very familiar to you, the Australian Standards of Record Management. And we have worked on the basis that, therefore, records include both physical and digital records, as well as other items such as those audio recordings and any visual recordings that we have, as well as photographs and artworks. We have also adopted a definition of record keeping to describe, in short, the creation, the use and the administration, including the management of those records. And for those of you who have looked at the consultation paper, you'll see that we've structured our consultation paper in that way to discuss those three stages of record keeping. Now let me turn to, having given a brief overview of the, I suppose, an outline of the work of the Commission, let me turn to why records and record keeping are such an important topic for this Royal Commission. I was explaining to David when I met him this morning that as I started to prepare this presentation, the list of reasons just got longer and longer. And in the end, I had to stop at the risk of treating each of those topics so superficially as for it to become not really of any meaning at all. So you can work on the basis that the area of topics I'm going to go through is not a finite list, and it's an ever-growing list of intersections between your work and areas of interest and ours. Let me start with the area that I know, I'm absolutely sure, Frank Golding will talk to you about this morning, and it is that area that touches upon those children and young people, now adults, who come to speak with us who have had an experience of being placed in some form of care during their lives. We have heard from a huge number of survivors, in particular in the out-of-home care sector. Sadly, many of whom have little or no or sketchy recollections of their childhood, and thus will go understandably, in search of records which may contain information for them about their childhoods and about their family connections. And as you can easily imagine, these searches are driven by many factors, including that person trying to understand who they are and where they come from, and what other family they might have, as well as from our area of work to find out whether or not there's any documentary evidence in the traditional language touching upon the traumatic events which have brought them before the Royal Commission or to the Royal Commission. And as I said, I'm sure you'll hear much more about the depth of pain and frustration attached to these issues from Frank and no doubt from Bonnie as well. We've heard in the course of those exchanges in private sessions from many people who've said they've been advised that in some instances records were never created, or they only contained very limited information or inaccurate or insensitive comments. And indeed, we too have encountered in our search for material a number of incidents where records have been lost, where they've been destroyed, where they've gone missing, where they are now completely unaccounted for. Just to go through a sense of the types of information that people are bringing to us about the impact on them of the loss of records in terms of the profoundly detrimental effects upon them. We've heard about people, as I've said to you, talking about their sense of loss of identity because their childhoods have been so fractured by the way in which they've been moved around and changed from place to place, but with no capacity then to put the pieces together because of a lack of a documentary trail. Not to mention, of course, as I've said, that disconnection from family, culture, language, heritage, loss of information about medical histories, and the list goes on and on. There's a whole other aspect, of course, to the themes that are emerging from our point of view with respect to those lost or damaged records. And as we have seen in some of our public hearings, records that have not been created completely ineffectively, have been lost, and lost sometimes in inverted commas, I think. We have seen that demonstrated starkly for us as then hampering an institution's ability to not only identify the actual allegations of sexual abuse that have been given to the institution, but also to identify risks. We've seen the loss of records or the inability to retrieve records or inadequate records delay or obstruct responses to allegations. And also, of course, patently obviously, hinder disciplinary action, redress efforts, civil proceedings as well as criminal proceedings. We've also seen it dramatically inhibit good governance. So, of course, decisions about governance can only be made if the decision-making body has a full and accurate understanding of what it is they're being asked to decide upon. And as I said, our public hearings have regularly provided stark illustrations of that. A whole other topic which has emerged for us, in particular for the care leavers or out-of-home care people that come to speak with us, is the difficulties of access to records. And we have heard many accounts being given to us about the way in which people feel that they are that difficulties and barriers are being put up in front of them with respect to them obtaining access to their own records. We have in particular heard about many victims and survivors still, despite all of the information that many of you would understand is out there about how to obtain records, given the particular issues, unfortunately, that many of the people in the out-of-home care sector are still carrying, they often feel very unsure about how to assert their rights to records about themselves, and of course some will feel completely ill-equipped to begin that process of requesting access to records, and indeed are even unsure about where to seek assistance in doing that. We've also understood that there are issues about costs that have faced some people, and also they have experienced, because some care leavers of course have crossed state boundaries, they've been moved from institutions from one state to another, and then they experience, as many of you would know, differing laws across differing jurisdictions, and for some that's a step too far, and they'll end up sadly giving up. Another topic altogether our work in this space throws up in terms of mentioning about state boundaries and crossing state boundaries. Some of you will have been engaged in perhaps giving advice or assisting in the setup of records and record-keeping practices when it comes to the establishment and maintenance of sex offender registers. Thank you. Sex offender registers and the operation of working with children checks. In New South Wales, there's something called a reportable conduct scheme, which is a much broader catchment of the expression of allegations and complaints to a range of particular authorities. And we are probably, through the Royal Commission, on the eve of those reportable conduct schemes, comparable schemes being set up across the state and territory borders in Australia, and that will bring very much its own issues about harmonising the way in which those systems must talk to each other. As I said, as I was going through the list of all the areas of interest, it got longer and longer. I thought of the significance of one of the stark issues that's thrown up for the Royal Commission, which is about the delay that's experienced for many victims and survivors in reporting to anybody, disclosing to family and friends and reporting to authorities. And it helps to drive home the significance of good record-keeping practices in institutions upon understanding that our figures to date show that it takes the average male victim of sexual abuse as a child 25.6 years to report, and the average female 20.6 years. Now, when this sobering information is put together with an understanding that a number of state jurisdictions are currently abolishing their statute of limitations, in other words, the previous legislative bars which time limit actions that can be commenced in civil law to recover damages for the harm that a person's experienced, the pressure on all institutions to maintain good record-keeping practices in that scenario, including, of course, well-archived records, will increase significantly. A discrete but related area to those previous 2 points, of course, is the increasing emphasis on information sharing as a prevention and detection and investigative tool for a range of institutions. So that information sharing needed, for example, to identify potential perpetrators and manage risks to children, as many of you would understand, is spread across time, across institutions, and unfortunately often across state boundaries. Obviously, information sharing means you've got good information to share kept in good records, so that's an underlying assumption to the value of record keeping. We have seen in both our private sessions, and I'm going to another discrete topic again, we have seen in our private sessions and case studies that many institutions have policies with respect to record keeping, but have not, or some of them, of course, haven't had policies, but some of them have had policies that they haven't enforced, and in particular for the creation and management of records about children in their care. Now, as I said, that list could go on and on, but it answers the question about why, from our point of view, we consider the issues of records and record-keeping practices as a very important part of the Royal Commission. Let me just give you a couple of examples, thank you. Just a couple of examples with respect to schools in particular that have thrown up a considerable number of issues for us. And rather than go through them in any detail for the purposes of time, let me just talk about the themes. We have discovered time and time again that there have been virtually no written records of any allegations contained in the records that we have compelled, consistent with what police and other authorities have found. We've had a large number of pieces of information given to us about lost or destroyed records. We've had an inordinately high number of floods and fires, apparently, when it comes to records. We have had other inquiries look at these issues in the sense that inquiries like the Bringing Them Home report, of course, have gone into the sadness for families and whole communities when their information about their own histories has been treated so poorly. And the impact upon them of even just understanding that. Many of you would know that for some of that quick list that I've just gone through, that there are still very much both these old problems remaining in contemporary settings and very much new and contemporary issues arising. And we too have been put on notice about that. Indeed, at our forum with respect to records keeping, we had input from some of the representative groups, no doubt sitting here today, and we're very grateful for that input. And we learnt of the issues that touch upon the volume with respect to maintaining records, changing formats and technologies. These issues, of course, have been of profound importance to us as we think about how to go forward. We have, you'll see in the consultation paper, set out 5 what we've called high-level principles. And if you haven't looked at those already and you are interested in giving us feedback, I do encourage you to have a look at that, even though technically our date for submissions has closed. If you really did have some concerns or issues you wanted to bring to our attention, I'm sure the team working on this would be very grateful to hear from you. Those principles, just quickly in summary, are principles about the creation and maintenance of accurate records, that should be a principle that is about the best interests of children, that accurate records must be created about all decisions and incidents that affect child protection. Records relevant to child sexual abuse must be appropriately maintained. Records relevant to child sexual abuse must only be disposed of subject to law or policy, and individuals' rights to access and amend records about them can only be restricted in accordance with law. As I said, we have sought submissions on what people think about those suggested 5 high-level principles. We certainly at this stage are not saying that those principles represent our final position at all. So just in conclusion, I hope I have conveyed to you our understanding that not only this area is such an important one for us, but an understanding that records and record keeping is an extremely complex area that provides not only, as I've said, the challenges of the past, but also some very contemporary challenges. We have observed, I'm pleased to say, good work going on, in particular in the government sector, finding ways to consider how best to tackle the number of records that they hold, responding to, as I've said, that significant amount of archival material. And we've heard evidence that, as some of you would know, but certainly was important evidence for us to consider, that some of those archives stretch over kilometres. And of course, understanding what that means in terms of the considerable challenges facing those who have to deal with those records. And as I've said, we are aware of all of the good work that's going on in the areas of the digitalisation of records and the improvements to access. Just finally, when individuals in organisations and institutions proactively maintain good records and record-keeping practices, and importantly foster a culture of doing so, in our view, they are supporting the safety of and well-being of the children that they serve. And it is our hope, and the hopes of many, that child-safe practices through good records and record-keeping governance will better protect children from future harm. And it is in recognition of the role that you in your work and your gathered expertise have and has to offer in this endeavour that we have taken up the offer to present to you today with such enthusiasm. I hope that in the very brief overview that I've been able to give you of some of the issues that we're grappling with, that you will be reassured of our acknowledgement of the crucial importance of the work that you do that affects our work. And so my other task is to convey my thanks and appreciation and acknowledgement to you for that. Thank you.